So, Tim, you mentioned suppression motions. I'm curious. I did a little research on it and was trying to learn more about it myself. What is a suppression motion, and how does it factor into a trial, and especially a trial's outcome?
Yeah, suppression motions, these are big deals, especially in the criminal defense world. Oftentimes, when by the time you take on a case, an accused or a defendant has already given a statement which is harmful to them, they've perhaps given up a cell phone, they've had evidence seized, maybe they've consented to a search, or that there was some search authorization that was given and maybe the scope was exceeded. So as a defense attorney, you can move a court or file a motion to suppress evidence. And what that essentially means is that the government can't use that in a trial. The typical ways we see motions to suppress are motion to suppress an accused statement or motion to suppress evidence. For example, if you're going to try to suppress an accused statement, for example, a statement to law enforcement, it happens all the time. We have military service members go in and they'll speak to OSI, CID, NCIS, and not really know their rights and waive their rights and think they're doing themselves a favor. And 6-7 hours later, they'll walk out making admissions or confessing to a crime, often one they didn't commit. So we'll file a motion to suppress that. When you file a motion to suppress, the burden is initially on the defense by preponderance of the evidence to show that the statement was involuntary. That's typically the standard, is the statement was not voluntarily given. And there are a whole host of factors regarding voluntariness, and it's a totality of the circumstances. That's the way a court looks at it. Once we raise the issue, the burden shifts over to the government, which is real interesting. Now they have to prove by preponderance of the evidence that the statement was voluntarily taken. So once we raise the issue and make a showing, the burden then shifts to the government to show that the statement was taken voluntarily. So what will happen? We'll file a written motion. These written motions, the one we filed, the last suppression motion, which we won, the motion was 65 pages long. This is 65 pages of written content, not including any exhibits, not including any enclosures, because these are highly, highly fact-driven. The courts know what the law is. The law doesn't change a lot on the issues of suppression, but the facts are what matters and how you argue the facts. So it's very important that you draft a comprehensive written motion and file that with the court. Now, the government's going to file their response. Their response can be as long. It typically is not. They typically mail it in and file some bullshit response. And then from there, it goes to court. And then once it goes to court, we have a hearing on it, and we're going to call witnesses. The government's going to call witnesses. And what we're litigating is whether the statement was voluntary or not, typically. And so what they're going to do is they're going to call the special agents who took the confession. They're going to go over whether they properly advised the accused of his rights, if he did a knowing and voluntary waiver of his rights. We'll go through all of the factors which could lead to voluntariness. And oftentimes, this is where experts get involved. The government will hire an expert, typically a forensic psychologist or a forensic psychiatrist, to go over all of the factors that can be involved in involuntary statement or in a false confession. We'll hire an expert or have an expert funded by the government, and we'll have what's called the battle of the experts to determine, was this statement voluntary? And in some examples, there can be the age of the accused, the intelligence of the accused, any mental health issues the accused had, and there's a whole host of factors that get involved here. And then the judge will make a ruling on it, and if the judge rules that the statement was involuntary or taken, or given under duress and the totality of the circumstance, the judge can suppress the statement. And that statement's not coming into evidence. That's a huge issue, because that statement's not going to come into trial against this accused or against a defendant, which is a game changer for trial. Now, what's also interesting is there may be ways where even if a confession is suppressed, it can still be used against your client, because what will happen is while the government may not be able to use the statement against an accused, if that accused testifies in their own defense, they may do what's called opening the door to it, and it may become admissible after the accused testifies. And so you have to understand that just because you go and let's say you win a big suppression issue, that suppression motion was granted, the accused statement's out there, but if your client testifies in his own defense, they may still be able to cross-examine him if his statements are inconsistent with his prior statements. So you may undo all the work you did by calling an accused to the witness stand. So it's really important that attorneys understand that just because something was suppressed, it doesn't mean it's suppressed forever. There are a lot of ways you can open the door to this. If you're a military service member and you've already made a statement, or you've given an admission or a confession that isn't true, or you've had a cell phone seized, or there's evidence that looks damning on its face that you think is going to be used against you at trial, let me tell you what, all hope is not lost. You still can fight this. You can still take this case to trial, and it can still be won. Give me a call at 813-669-3500 or do additional research at my website, BileckiLawGroup.com, and get us into the fight.